This is San Antonio, Texas attorney Alan Tysinger talking about Texas workers' compensation, wrongful termination, and retaliation claims. So looking at the law, we're dealing with Texas Labor Code Section 451. Texas Labor Code Section 451 provides that it is illegal for an employer to fire or discriminate against, retaliate against an employee because the employee has pursued a workers' compensation claim. The exact language is, a person may not discharge or in any manner discriminate against an employee because the employee has filed a workers' compensation claim in good faith, hired a lawyer to represent the employee in a claim, instituted or caused to be instituted in good faith a proceeding under Subtitle A, a workers' compensation claim, or testified or is about to testify in a proceeding under Subtitle A, in other words, a workers' compensation hearing. Now, in Texas, generally, employment is at will. In other words, an employer can terminate an employee for a good reason or no reason at all. And the exceptions have to do with certain protected classes or protected behavior, such as a protected status, like the employee is of a minority, an ethnic minority, or the employee is a certain sex or gender, and the employee is terminated for that reason. Those things are illegal under the law, but if the employer wants to terminate the employee for a bad reason, in other words, doesn't make sense, not very well thought out, not fair, those things are not illegal. The exceptions to that would be things like workers' compensation retaliation. You see this in cases where an employee gets hurt and the employer is upset because the employee is now going to be out of work, so they have to fill that job with somebody else, or they have to hold the job open while the employee recovers. Their workers' compensation claim costs are going to go up. And if the employee was injured by a vendor or contractor that the employer works with, that vendor or contractor might be sued by the employee, creating friction between the two companies, which may give rise to the employer retaliating against the injured employee who was injured through no fault of his or her own. The burden of proof is on the employee in these cases. So Section 451.002 provides that reasonable damages would be paid by the employer for violation of this section of the law, and the employee has the burden to prove that the termination or retaliation was because of the workplace injury or related factors like I mentioned a moment ago. Now, the general truth about this is that most of the time employers aren't going to tell you, I'm mad because you got hurt on the job and you're filing it under workers' comp, you're fired. That rarely happens. Occasionally an employer will cross the line and do that, but most of the time it's going to be an inference from other facts. In other words, they terminate the employee and the reason doesn't hold up under logical scrutiny or factual scrutiny, and there are other facts surrounding that that cause you to conclude that it really was about the workers' compensation injury, such as it being very close in time to the workers' compensation injury, or prior comments the employer may have made about safety needing to stay at 100%, no lost time being a major policy, about bonuses being tied to the lack of workplace injuries, and even comments about how they may have treated other employees in the past, like so-and-so got hurt and you saw what we did, so you better keep it on the down low if something happens to you here. Those kinds of warnings, threats, even when they're not that explicit, can be the basis of a workers' compensation retaliation claim, and an employee can pursue that because it really defeats the whole purpose of having workers' compensation insurance as a protection for employees if the employee can't count on that without jeopardizing his or her job.